Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today may be the day I earn your subscription. For today's case, we're dealing with a transgender inmate who wants to have surgery to conform to their new identity, but the state of Texas doesn't want to give it to them for free. So we're going to discuss the law as it applies in this case. The case of David Allen Hamperkamp, also known as Bobby Lee, and Dr. Lynette Lithicum and et al. So we're going to look at this and see what the standards are. Let's get started with this. Texas state prisoner David Allen Haverkamp, also known as Bobby Lee Haverkamp, a biological male at birth who identifies as transgender woman, sued state officials alleging violations of Equal Protection Clause of the United States. Specifically, plaintiff alleges defendants violate equal protection by denying medically necessary sex reassignment surgery and failing to provide certain female compensatory items and long hair pass. I'm not sure. Please correct me if I'm wrong, and maybe I'm speaking out of turn. But why would a transgender male turned female need female specific compensatory products? Why would they need those things? I'm just slightly confused, but okay. We begin with a brief overview of the structure of Texas's healthcare system for prisoners. The Texas Department of Criminal Justice contracts with the University of Texas Medical Branch to provide medical and psychiatric services to inmates, including the plaintiff. The committee that oversees all this is tasked with developing and approving a managed health care plan that specifies types and general level of care for inmates and ensures continued access to needed care in a correctional health system. Haverkamp, who identifies as a transgender woman, is incarcerated by the Texas Department of Criminal Justice in a men's prison. In 2017, by the way, just in case those of you who are asking, there's a footnote. Haverkamp was convicted of 2 counts of aggravated sexual assault in 1994 and sentenced to 45 years in prison, just in case you wanted to know. In 2017, Haverkamp filed a pro se suit in federal court alleging the physicians who worked with and for the state violated the 8th and 14th Amendments by refusing to provide the sex reassignment surgery. Nail polish? I don't know, but if I were a betting man, I'm just going to go on a guess and assume that the prison doesn't make nail polish available. Just a guess, though. The magistrate judge held a hearing with the parties and raised the issue as to whether proper defendants had been named in this case. So initially, the magistrate judge is saying, I think you might have sued the wrong people. The counsel for Texas stated the appropriate defendants in this case hinge on the type of relief sought, which is perfectly reasonable, right? Who you have to sue depends on what you're trying to get done. The counsel explained that in the event plaintiff only seeks gender reassignment surgery, the appropriate defendant would be Dr. Owen Murphy from the Health Supply Services. And if plaintiff seeks a policy change or new policy regarding care for transgender inmates, the appropriate defendant will be the principal members of the committee. So, what exactly are you asking for? Based on the state's representations, the magistrate judge ordered Haverkamp file an amended complaint and proposed that Haverkamp name Dr. Murray and each of the principal committee members in their official capacities, as the plaintiff only seeks injunctive relief. The court permitted plaintiff to name defendants as John and Jane Doe and explained that they would be able to ascertain their identities of the precise parties once state filed the advisory. So the magistrate judge is looking out for a pro se, which, is perfectly reasonable. Judges will try to help pro ses when they feel like they're not being jerked around. So it's like, I think you sued the wrong people. And the state of Texas says, well, it depends on what you want. And here's different people you can sue. And so the magistrate judge says, okay, amend your complaint to sue these people instead of these people. And you can also put in a John Doe because we don't know exactly who they are right now, but we'll substitute the names once the state of Texas tells us. So, fair enough. In October of 2017, Haverkamp filed a written pro se amended complaint, which is the operative complaint. According to this complaint, Haverkamp was diagnosed with gender dysphoria in 2013. a condition which the American Psychiatric Association defines in its most recent Diagnostic and Statistical Manual, the DSM-5, as a marked incongruence between one experienced expressed gender and assigned gender of at least 6 months duration. So, yeah, you have officially a mental illness because of this. You have gender dysphoria because your believed sex and assigned sex are different. So you have a mental impairment, which, yeah, okay. 3 months into the 12-month hormone regimen, Dr. Meyer told Haverkamp, the medical board, which provides medical care to the inmates, is going to have to face the inevitability that gender reassignment surgery is going to happen. In September of 2015, near the end of the year-long course of hormone treatment, Haverkamp met with Dr. Meyer and a nurse and was told very plainly that the department would not pay for surgery. So, yeah, this is the conflict, right? They're willing to pay for the hormone stuff, but they're not willing to pay for the surgery. So we have to decide, at least in part, whether the state has to provide this form of care at state expense. All right, let's carry on. The operative complaint references and attaches a policy which is promulgated by the committee concerning the treatment of gender disorders. Haverkamp alleges the policy constitutes a contract guaranteeing the right to sex reassignment surgery and defendants have breached the contract. No, that doesn't make any sense. It can't possibly be a contract. In order to have a contract, you have to have two parties, and there has to be mutual consideration. And consideration means some sort of legal obligation you weren't otherwise required to give, right? If you're required to give it, it doesn't count as consideration. It has to be something new. Usually this is money, by the way. Most contracts is, I want thing, I give you money. Neither party was required at the start to do that, right? Neither party was required to exchange property for money. So they say, I'll give you property for money. New contract. Great. Right? All right. So why can't this be a contract? Well, the department has a policy. And how is it a breach of contract to you? What legal detriment did you give? None. You're a prisoner. You're required to be a prisoner. So it's like, oh, I'm a prisoner. I'm like, yeah, but you're required to do that. So you don't have new consideration. So it can't possibly be contract, one would think. In 2018, Texas filed an advisory listing that indicated the 10 principal members of the committee. Based on the state's advisory, the district court ordered the services of Haverkamp's operative complaint on Dr. Murray, who the state earlier identified as a proper defendant if they were seeking the surgery, and the 9 committee members who had not yet been named as parties. So the district court, again, is ordering a change of parties because you sued the wrong people, but you're pro se, so we'll help you out. Okay. Subsequently, several members of the committee filed a motion to dismiss. Later that month, other committee members filed a motion to dismiss, contending that Haverkamp lacked standing because they could not redress the injuries, the suit was barred by sovereign immunity, and the suit failed to plausibly allege equal protection. The district court denied the motion. First, the court reasoned that Haverkamp plausibly alleged the committee members directly impacted the treatment plan, and the state had provided vague and sometimes conflicting guidance as to the identity of proper defendants. Second, the court held that Haverkamp's claim met the requirements of ex partes Young's exception to sovereign immunity. Last, the court held that Haverkamp stated an equal protection claim for reasons provided in October. The committee appeals. So the district court says, yeah, you did it bad. You did it bad. You're interfering with the surgery. You're not giving them protections. You're violating federal law. So all those things. So yeah, and so the committee members very unsurprisingly appeal. The denial of an 11th Amendment sovereign immunity is immediately appealable under collateral order doctrine. So, yeah, if you can appeal for other reasons, then you can appeal for this too. The Supreme Court has carved out an exception to state immunity in ex parte Young, which permits suits against state actors when they violate the federal law. In this case, it's undisputed that Texas has not consented to the suit, and Congress has not abrogated state immunity. The question then is where defendants are subject to suit under ex parte Young exception. For a plaintiff to invoke ex parte Young, the state official sued must have some connection with the enforcement of the Challenge Act, or else the suit is merely making him a party to represent the state and thereby attempting to make the state a party. So yeah, if you are suing the state official for their official acts, you're basically trying to sue the state. That's what they say. Moreover, whether a suit may proceed under Ex parte Young does not require analysis of merits. Rather, a court need only to conduct a straightforward inquiry as to whether the complaint alleges an ongoing violation of federal law and seeks relief properly characterized as prospective. While the circumstances do suggest a disagreement between the doctor and the prison concerning the provision of sex reassignment surgery, even though there's no clear allegation that Dr. Meyer continued to recommend this surgery at the end of the year-long course of hormone therapy, the amended complaint does not allege which Department of Criminal Justice official, if any, decided that they wouldn't pay for the surgery. So you didn't say, like, who made this order from the state. Whether the doctor or anyone else challenged that decision and brought it before the committee, that you saw, basically that you exhausted administrative remedies, or at least sought administrative remedies, or that the commission adjudicated any dispute between the prison and Haverkamp's healthcare provider concerning the surgery, or rendered a decision that they aggrieved Haverkamp, perhaps by enforcing policy so as to deny surgery. So yeah, in this case, the court is basically saying, look, there's not enough facts here that are on point, right? You could have appealed it to the committee. You could have sought that relief. Last, Haverkamp appears to suggest that it's inequitable for Texas to assert that these defendants are entitled to sovereign immunity when the state has not identified any other person or entity that would have the responsibility for enforcing the policy or actually made the decision to deny the surgery. This argument is ultimately unavailing because the burden of proof is on the party asserting jurisdiction. It sure is. Texas has identified the parties Haverkamp should sue, but it remains Haverkamp's burden to plead these parties' connections to the enforcement of the decision. Yeah, you should sue them, but you have to say how those people did things. Like, what is their role in this? Because we conclude Haverkamp's operative complaint does not accurately plead the defendants have sufficient connection to the enforcement of the act, we must vacate the district court's order denying the state's sovereign immunity defense. Thus, that brings us to the end of the case of David Allen Haverkamp, also known as Bobby Lees, versus a whole bunch of people. In this case, Bobby here wants some sex reassignment surgery. And they say, look, you're in violation of policy on this. You're in violation of my rights. And the court of appeals notes, look, you didn't follow through. You went through this whole procedure, but it's not clear that the whole hormone procedure, but it's not clear the doctor was necessarily still recommending it. It's definitely not the case that you went to the committee and argued it. So you don't have a final decision on this from the administration. And as I noted, under federal law, you have to exhaust administrative remedies, and you didn't do that. So, you're defective in your case. So, yeah, Bobby Lee here will continue to have male parts for the foreseeable future, and at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.